So please tell us who you are, where you're from, and ask your question.
Thank you, Mark. My name is Craig White, and I live in Buncombe County. And Dr. Grant, I absolutely agree. I think we need to bring some respect back into the room. We are not going to agree at the end of the night. We are not going to share our faith perspectives at the end of the night. But tomorrow morning, y'all are still all going to be my neighbors, even though we disagree. My question is for Reverend Dr. Grant and for Reverend Hoffman. I know y'all have been involved in some dialogue efforts trying to build respect and understanding across these differences. Would y'all be willing to speak to that a little bit?
Yes, thank you. My experience has been and I've been in forums like these before, is that when you respectfully disagree with same-sex marriage or the homosexual lifestyle, then you are automatically labeled as unintelligent, backwards, not progressive, uninformed, ignorant, homophobic, stupid. You know, we get into this name-calling game. And I've had discussions with the gentleman here about this. I don't see that on the side that I represent. I'm sure it's there to some extent, but I'm just talking about even here tonight. I heard somebody get up and say, if you call yourself a Christian, and then, well, how can you disagree with this and be loving? So the problem I have is that people are equating loving other people with agreeing with their lifestyle. And that's a fallacy. I can respect you and you can respect me, and we don't have to get into calling each other's name. You are not unintelligent because I don't agree with you.
And John,
because you disagree with me.
John, the question was about the dialogue between the two pastors, and Joe, I want to bring you into this debate.
Thank you. I apologize for the name calling that happens on both sides, and I say that because we've gotten really good at it, and we're not as good at conversation as I'd like to see us be again. I think that's the same thing that's happening in Washington and in Raleigh. We're good at saying, this is what I believe, and I don't want to listen to what you have to say. But what I'm hoping in these conversations, and I'm really grateful to sit at the table with John and others in this room and other clergy in our community, that there's a whole lot more that we agree on. We do important work in this community, and I consider John my brother and my friend, my colleague. I would like to be able to have those respectful conversations, and I think we're learning to do that.
And I think we've had them.
Yes.
We had two of us.
I think we have, and I think what can come from that is, instead of just me saying this is what I think and this is what he thinks, we can tell some stories, and we can say, you know, this is why I think that. This was my experience. And we get underneath that and we build relationship with each other. And we may never agree on this particular issue, but then we can be neighbors with each other, and we can work together, and we can love each other, and we will love the people that we disagree with as well as the people that we agree with.
And don't try to thrust something down my throat and then call me a bigot because I refuse to swallow it.
And for my audience, in the opinion of the moderator, actually, the fact that they're actually having a conversation, I think, deserves a round of applause from everybody. I've got people in the front and the back of the room. I know I've got two gentlemen lined up I'm going to get to. Before I do that, where's Roger from Western Carolina University? Come on back here, because I'm going to put the professor on the spot, because we've had the discussion that as soon, perhaps as early as tomorrow, the Supreme Court may offer an opinion on Proposition 8 and DOMA, the Defense of Marriage Act. So I'm going to put the professor in the spot, who kind of deals in this space a little bit. Can you give us maybe a minute or so of what you think might come out, or if you can't go that far, at least what you think what's going to occur afterwards?
Oh, great. Great question. There are actually two cases. One is the Hollingsworth case. Is about Proposition 8 in California, and the second case is United States versus Windsor, which is a case that deals with the Defense of Marriage Act, which was passed by the United States government and signed into law by President Clinton, as it turns out. There are two different challenges, both of which are going to be very important no matter which direction they go. The first case, dealing with the Hollingsworth case, it deals with the California Proposition 8 question, actually deals with the heart of whether an individual has a right to marry in the state of California, or in fact in the entire Ninth Circuit, and potentially, if the court went really, really far, they could say the entire United States. There are a lot of legal experts that are arguing right now that the court will probably not go that far and provide a complete legal marriage to everyone in the United States, in a sense saying that if you live in North Carolina or Alabama, all of a sudden same-sex marriage is legal here. That said, the court could, in fact, make it legal in California. It could do lots of things, or it could say, on the other hand, that same-sex marriage is still illegal in California. The other case, the Hollingsworth case, or not Hollingsworth, sorry, the Windsor case deals with the federal government and primarily benefits. The Defense of Marriage Act has several provisions to it. This one deals with only one provision, which essentially says that same-sex couples are not entitled to the same federal benefits as are married couples, and it defines marriage between a man and a woman, as it turns out. There is another provision that is really interesting that is not actually under challenge, which is provision 2, which essentially says that no state is forced to recognize a couple married from another state if they move to a state where marriage is not legal, which means even after tomorrow, that will still be on the books unless the court found some wild way to reach it, and I doubt they will. But even tomorrow, after that decision, if it comes down, if a person marries in the state of Massachusetts and moves to North Carolina, they're essentially not afforded the same marital rights that they did when they were in the state of Massachusetts or the other 12 states. There are lots of ways that this could go, and there are actually some legal ways that the court could avoid the issue, which would essentially say that the petitioners or those defending these cases did not have standing to actually be in the case in the first place. It essentially means that those who are challenging the law win. What does that mean to everyone here? That means in the state of California, California likely would be a marriage state. Again, because it was once a marriage state for about 4 months.
If I get you to wrap up here in another
Sorry.
moment.
Sure. And in the, well, it's really complex, and we'll all read about it tomorrow if it does come down tomorrow. But on the federal benefits case, the issue could go a lot of different ways, frankly. What it could mean, if the court does strike down that provision of DOMA, what it would mean is in those 12 states where it's legal to marry, you would get federal benefits. What we don't know, though, is what if you move from one of those 12 states to another state like North Carolina? Do those federal benefits come with you in a state that does not recognize marriage? That is a tricky legal issue. So what I always tell my students is, it doesn't matter what the Supreme Court says tomorrow. It matters what happens after the Supreme Court says what it says tomorrow. What the devil is in the details. The devil is also in implementation, how it's carried out.
Great, thank you. And this doesn't apply to our viewers at home, but everyone here present has to take a quiz afterwards. I want this gentleman over here. Please, you join me. And I know I have a gentleman back here who's been very patient as well. So I know everyone's been patient. Please tell us who you are, where you're from, and ask your question.
My name is Dan Marchesoni. I'm from here in Mills River. I think we all know that the Founding Fathers were very conscious of the dangers of allowing the majority to trample the rights of the minority. My question is for the two gentlemen on the right. If you put aside the religious aspect of this question for a few minutes, how do you reconcile that with your views?
We've heard a lot from John. I'm going to go over to Ken for a moment because let's talk about it. Is there a religious component to this? And just for the record, I know we've already had the professor. I believe you were involved in, Ken, in writing some of the briefs that were argued before the Supreme
That's
Court?
correct. I'm a lawyer in the litigation.
Okay.
It's, well, the role of the courts are what's called a counter-majoritarian institution. They are to protect the minority against the minority. But they are not to do so according to whatever they think is fair. They are to abide by the law as it's written. Now, when it's the Constitution, that's the supreme law of the land, it trumps all. Constitution trumps statute, statutes trump regulation. Where there is no positive law and no common law, a judge has no role. It becomes a public policy question that is decided by the elected representatives. We vote on everything in this country. We either vote for it directly, like amending a state constitution, or we vote for elected leaders who make laws, or we vote to put something in the Constitution. But there's never something where unelected judges get to make public policy for us. It all starts with we the people. That's the cornerstone principle of the constitutional framework.
All right, actually, and I want to get the professor here. I think you want to make a quick comment.
I would disagree on that last point. You're advancing one form of legal interpretation.
If you could stand up and speak a little louder so everybody can hear you.
Sorry, I would disagree, and there's a lot of people in America, a lot of lawyers that would disagree, and a lot of constitutional scholars that would disagree with the theory of law that you've advanced, which is that the law only means what the words say and that the law only means what the framers of the Constitution say. Respectfully, that is a very important legal discourse in the country. But there is also a legal discourse that is written very plainly in the U.S. Constitution that says the U.S. Supreme Court has the power to interpret the law. Interpret the law. Interpretation changes with the times. Another theory of legal interpretation is that as times change, and as laws change as well. And the law is not fundamentally only what the Constitution says, it is what previous precedents have said, and law builds upon itself over time. Right. You and I will disagree on those types of philosophy, but you have to recognize that that is absolutely, for conservatives and liberals in different legal issues, for conservatives and liberals, activism or the changing of law through precedent is a legitimate form of legal interpretation, as is at times original intent.
And let me get a quick response in from Ken, and then we'll probably move on from this
absolutely.
topic.
Yeah, so I too am on faculty at a law school, and I'll give an example as to where this came up in 2008. Whether the Second Amendment right to keep and bear arms means that any private citizen has any right to own a gun. That was a 5-4 decision. There were 4 justices who just don't like guns, and so they say, I know what the words say, but the meaning has changed. No one has a right to own a gun. That is a scary thought, that judges can look at such plain, straightforward language and say, because I don't like it, I will say it's not the law. That takes things out of the hands of the people and invest them in people who never have to answer to the voters. I acknowledge the reality of the debate, but that's where I disagree with judicial activism, the idea that judges ever have license to just run the country for us no matter what we say at the ballot.
Look, I want to leave it there on that particular issue and get back to a few more audience member questions. Before I do that, I have another snap poll. I'd like you to respond to the following statement. By a sound of applause, your choices are yes and no. My statement: news organizations have presented the same-sex marriage issue in a thoughtful, impartial, and balanced approach. Those who believe yes, please applaud. Those who believe no, please applaud. I guess that means I have to post my resume online tomorrow morning.